to be entrenched in legislation. We've advanced to this committee copies of 4 reports we have prepared on this subject. Legislating this office and having a report to Parliament is both symbolic and practical. Most importantly, it would place the fair treatment of our constituents above politics. En juin 2022, en plein cœur de la crise des enquêtes.
In the middle of the crisis on these investigations, I held a press conference to address some specific issues to increase accountability, which remains an issue today. A number of crises have undermined confidence versus the department and the Canadian Armed Forces. Mechanisms are not actually independent from these institutions. I hope that the committee's consensus will be relating to legislation to reestablish confidence in the institution.
My organization is subject to oversight and investigation by the same department it is mandated to oversee. The conflict here is obvious. In the past, this has resulted in problematic investigations of this office that completely lacked credibility. In one case, the department investigated my predecessor and staff in a process so riddled with procedural defects and unfairness that it raised concerns that the process was being abused. For one implicated member of our staff, the federal court was categorical. The individual, quote, was denied procedural fairness in the investigation and in the decision-making process, end quote. No one has yet been held accountable. There is nothing to prevent this from happening again. Le ministre de la Défense nationale n'est pas tenu par la...
The minister does not have to follow up on the recommendations in the reports from the Ombudsman's office. Our reports are based on evidence, and they aim to address systemic issues that the Defence Community is faced with.
Responses to our reports are increasingly months late and contain no tangible implementation details, despite the fact that we know the department has developed them. Where is the choke point? Soyons clairs, en ce qui concerne les dossiers.
Let us be clear. With respect to individual cases, our organization does an extremely good job in achieving fair results.
Recommendations, the department and the CAF have not progressed sufficiently. We have historically lacked evidence on the implementation of these recommendations. Consequently, we regularly follow up with the department and the CAF and issue report cards based on what we see. This is a best practice in oversight, but the results are often not promising. À l'automne 2023,
in the fall 2023, I published a report on the determination of the needs with respect to mental health and support for reserve members who take part in national operations. 5 months later, I have yet to receive a response from the minister.
This post on July 2nd this year, I will release a report that will address issues related to CAF complaint mechanisms. Will we have to wait months again for a response? Is this how you wish accountability to work? Il y a 3 semaines, devant ce comité,
3 weeks ago, before this committee, I indicated that the problems related to family are the main reason why military members leave the Canadian Forces. Logically, solving these problems would help with retention. Our office reports and has been reporting these issues for over 10 years.
Unaffected by these issues facing military members and their families. That is precisely why, in the estimation of myself and my predecessors, this office needs to report to the People's House, this House, and not just one member of it, especially when the issues involve more than the Department of National Defence and could be matters of national security. Ministerial responses to previous governance reports have usually been things are fine, and if they are not, pick up the phone and call me. But as my predecessor faced in 2018, what happens when this person is the source of the problem or refuses to listen? If I cannot get the attention of the minister, should I set up more meetings with members of all parties? Should I resort to using the media? How does Parliament want to ensure ministerial accountability if it does not have a completely independent body providing it with advice and recommendations? We have fully legislated oversight for federally incarcerated inmates, those who commit serious crimes. Why do those who proudly wear a military uniform, on whom we depend for national security, not have the same? Cela n'a pas de sens.
It makes no sense, Canada.
Is to not have legislative military oversight. You can change that. Thank you. Merci.
Thank you, Mr. Lick. Mr. Josie, 5 minutes, please.
Monsieur le Président,
Mr. Chair, committee members, good day. Thank you for having me join this important meeting today. I'm Vihar Joshi. I'm interim chair of the External Committee. To be concise, I will be addressing the work that we do at the Military Grievances External Review Committee by using the term MGRC, which is the acronym. MGRC is an external component that is an integral part of the grievance system within the forces. It was created in June 2000 under the National Defense Act. MGRC is a quasi-judicial body that is at arm's length and has only one mandate: to examine the grievances that are sent to it through the Chief of the Defense Staff and to issue conclusions and recommendations to the Chief of the Defense Staff and to the military members having filed a grievance. The Chief of the Defense Staff is not held by these conclusions and recommendations, but if the Canadian Armed Forces decide not to implement one of these recommendations, they have to explain their grounds for not doing so.
does not have decision-making power. Its role is nonetheless pivotal in maintaining transparency and confidence in the Canadian Armed Forces grievance system. At arm's length from the Canadian Forces, the MGRC has developed considerable expertise over the past 23 years and is well positioned to undertake in-depth investigations into grievance matters and provide impartial and independent assessment to both the Chief of the Defence Staff and grievers on how a grievance should be resolved. The MGRC provides its annual report to Parliament through the Minister of National Defence. Online, it publishes its annual reports, case summaries, and systemic recommendations, thereby further strengthening transparency. Although the regulations only require that certain types of grievances be referred to the MGRC for review, all grievers should benefit from an external, independent review before a final decision is made on the grievance. Not only has this notion been highlighted by independent review authorities, including Mr. Justice Fish in his recent third independent review, but until recently, it has also been a Canadian Armed Forces best practice for the past 13 years. To ensure that all grievers benefit from this review, this practice should be entrenched in legislation. Justice Fish also made a number of other recommendations to enhance the transparency and efficiency of the Canadian Armed Forces grievance system, and the MGRC looks forward to working with the Canadian Armed Forces to improve the grievance system for all soldiers, sailors, and aviators. With regard to access to information requests and parliamentary questions, I can confirm that in the last 5 years, the MGRC has responded, on average, to 116 parliamentary questions, 3 formal access to information requests, and 19 informal access to information requests. In the interest of efficiency and to reduce the administrative burden on those making requests, it is the MGRC's standard best practice to respond quickly and without need to initiate the formal access to information request process. The MGRC's specific role in the Canadian Armed Forces grievance system is valuable and important. In essence, it increases transparency and confidence in the system by ensuring that grievers have full disclosure of all relevant information and that their grievances have an in-depth, independent, and impartial review before the Chief of Defence Staff renders final decisions. We have heard time and again from both grievers and the Chief of Defence Staff that the quality and thoroughness of our reviews adds value to the process. Je vous remercie de m'avoir donné l'occasion.
I thank you for giving me the time to speak to you today, and I'd be pleased to respond to your questions.
Thank you very much. Merci.
Thank you, Mr. Josie. We go to our 6-minute round. starting with Mr. Kelly, Madame Dombropoulos, Norman Dean, Matheson. Mr. Kelly.
Thank you to our audiences. Mr. Josie, in your 2022 annual report, so it's less than 2 years ago, you said that for the three out of the last 5 years, your ability to deliver on your mandate was hampered by lapses in governor and council appointees' tenure. So how many governor and council appointments have lapsed, and for how long in the last 5 years?
So in the last 5 years, we've had 2 lapses. In 2018, we came up to full complement. And in 2022, the vice chair full-time left the committee, and the chair left the committee in the summer of 2022, and those positions have not been filled yet.
Okay, so this is a troubling trend that goes along with the non-appointment of judges that we see, delays in the government appointing so that these bodies can do their work. How are you concerned? How about the cuts that are proposed? They're going to cut $1 billion in the defense budget. We've been promised at this committee that will not affect operational readiness or direct frontline forces. Are you concerned that it's going to be the transparency mechanisms that suffer under the cuts that are coming?
So in respect of our committee, I do not have any fears or any concerns in the sense that our budget at this point has not been affected. Okay. And in fact, we've been able to increase slightly our budget to increase our staffing levels to deal with a higher number of grievances.
Okay, but you don't have the appointments, though, so that the hearings can take place, that's slowing down your work, you had said.
We do lack members at this present time still.
Okay, thank you. Mr. Lick, how long does it take complainants to get to the stage of asking your office to assist? If they've got to go through the MGIRC first, how long does it take typically before they get to you?
So first of all, they can access our services at any point in time. It does not matter, and we will make sure they get on the right path to get the right recourse mechanism, if that's the case, or get the information, whatever it is. But they can access it at any time. It does not matter.
Okay. So my office and other MP offices have heard from veterans who have filed privacy requests for information on sexual misconduct cases and have ended up having the charges stayed against the alleged offender for lack of timely delivery of the information necessary to make a complaint and to make the case. How does the denial of this type of information affect morale and affect serving members and their families when they can't get the information that they need from the military to be able to carry out a complaint?
So first of all, in the area of law enforcement or judicial proceedings like that, we are prevented from looking at that area in particular, or any criminal matters in that regard. But I think in general, your question in general, being able to access information to be able to support their lives, their careers, whatever, that is morale damaging when they can't get the information in time. One of the roles of our office is to make sure that we can get that information to them in time, and they can access our services if they're finding it difficult to get that information, except for criminal matters.
What about medical information for retiring CAF members?
So in some of our previous reports, we outlined some of the issues that we saw with the problems in getting information for the member to access their records and so on, or from VAC to making a judicial decision, or rather a adjudication on their particular benefits. It is better now. They can access those services, access that information as they release, but they still run into some of the similar simple problems, like they give it on a CD perhaps, but many people don't have CD players anymore. So they're working through that issue right now. I think it is getting better, definitely, but whatever it is, they can access their information, maybe not in as timely manner as we would like to see, though.
Okay, are there persistent problems still with those with service injuries, having to then reprove their injury once they discharge from the CAF?
Yeah, and that's one of our recommendations that was not accepted by the department, and that was to have the CAF or the Military Health Services make that decision on service attribution of an injury. We still believe in that, absolutely, because it seems to be the most logical, the most efficient way of doing it, but they've been reluctant to look at that since our report previously.
Wow. Why won't they do it?
At the time, and I'll ask Robin perhaps to supplement this, but at the time they brought up the ethical issues of a treating doctor providing that decision. There are ways to get around that. They could have a separate group within the organization do it, separate from the treating doctor, but that was the issue that they brought up at the time.
Does an injured force member take any comfort from that explanation?
I wouldn't say so. I think the point is we want to see retiring members get those benefits that they deserve as quickly as possible, and in fact, get it before they get the adjudication decision before they leave the forces. Yeah. So that they have every piece of information, all the benefits in place, all the services in place before they leave.
Right, because we are sometimes talking about members that are discharged for medical that it's a medical discharge, and then are unable to access benefits for the injuries that were the source of the discharge.
Exactly.
Madame Lambropoulos, 6 minutes.
Thanks, Chair. My first question is going to go to Mr. Lick. Thank you for being here with us today. And you mentioned that 5 months ago you had sent a letter, I guess, to the minister regarding mental health. And so I'm wondering, I know you said that you hadn't heard back in 5 months. I'm wondering if prior to this, you had similar experiences, if you actually have written and received responses in a timely manner, if you can comment further on other times that you've tried to communicate with the minister's office.
No, in the history since I started in 2018, we are experiencing the same problems and delays of getting information from the department, in this case the minister and the minister's office, with respect to our systemic recommendations. We know that the department, in our discussions with them, have been working on these these recommendations, whether to implement them or to action them. However, for some reason, we can't get an answer from the department, officially the minister and the minister's office, in a timely manner. And this affects I think more than anything, the transparency of this whole institution. When we made a recommendation, they don't have they have the right to not accept it. Absolutely, that's fine. But at the same time, our defense community deserves an answer, yes or no, absolutely, but we're not getting it in a timely manner. We don't understand why.
Okay, thank you. And you also mentioned that Canada is one of the only countries without a legislative military oversight. And I'm wondering if you can go a little into detail as to how this would be helpful in this case, or in general, in order to improve transparency.
Well, certainly we can provide this committee with a chart of that information, absolutely, for all the world that we have that information. But certainly in the area of the Five Eyes, our most closely linked communities that we work in and countries that we work with, we are the only one that does not have a legislated mandate for its ombudsperson, ombudsman, whatever they call them, inspector general, whatever it might be. And I think what I've said in numerous reports, and my predecessors have said in numerous reports, that more than anything, it is sometimes the perception of interference, sometimes real interference that does occur, that causes our inability to actually action some of the investigations that we carry out. It is also being able to raise issues or escalate issues beyond the minister or the government in power at the time to the parliament. I can use the media, absolutely. I can talk to all different political parties, but is that really how ministerial accountability should work? I don't believe so. I think I need to report to Parliament to bring these issues to Parliament, whether it's at a committee, whether it's in other ways, but ultimately it is that. But the other aspect is legislation also provides protection for being compelled as a witness in a particular case. That is important. The Correctional Services investigator, as an example, has that. I do not. I will fight back if I'm asked to do that, and I'll fight it in court if I need to, but really that should be protected in legislation to protect the confidentiality of the services we provide to our constituents.
Thank you very much. My next question will go to Mr. Joshi, I've heard different versions. Joshi, I thought so. So we heard about the military grievance process, and we know that in order to improve the culture of the CAF, we need to improve the grievance process and make sure that people are having a fair and timely response. And so I'm wondering if you can suggest any specific improvements that you think that would help us as it relates to access to information.
So one of the big things I would suggest is, as I mentioned before, having all of the grievances come to us discretionary or mandatory, as we call them. And how does this help? First of all, with access to information, it would give all grievers the disclosure they need to have their grievances properly considered. It would give an impartial and independent review back to the Chief of Defence Staff. While it looks like it would take more time to send all of those files to the Grievance Committee, at the end of the day, it saves time in the process. Why? Because what the Canadian Armed Forces gets back and what the member gets back is a fully analyzed file with all the information contained in it, the logic flow of how we arrive at a recommendation and a conclusion and a recommendation. So when it gets back to the final authority, they have that complete file. They can review it, they have an independent opinion on it, and it explains to grievers also why the committee or why we feel their file should be decided in a certain way. So that gives some transparency and boosts confidence in the system.
And so currently you do have to go through regular access to information requests, I imagine, which takes longer?
We do not.
You don't?
For us, in the National Defence Act, there's a provision that when the Chief of Defence Staff refers a file to the committee, the Chief of Defence Staff is required to provide us with all relevant information. And to the extent that we don't get a full file or there's information missing, we have lines of communication with the Canadian Armed Forces that allows us to get that information. Of course, sometimes it takes time because, as we know, grievances are not necessarily the priority of the organization that way. They have an operation to run, but we do have a system in place to get the information back.
How much time do I have left? Okay, well, thank you both very much, and to Ms. Hines, too.
Thank you, Madame Lavropoulos. 6 minutes, Madame Normandin.
Merci beaucoup à l'ensemble.
6 minutes. Thank you to the witnesses. Mr. Joshi, I'll start with you because I think it's a follow-up to Madame Lambropoulos' questions. You mentioned that not all grievances are referred to your review committee. On what basis are some sent there and some not? Do you have any idea as to why some are referred and others not? Perhaps through that very selection, could there not be actually embedded in it a lack of transparency, hiding something?
To referrals to the committee, there are two types of referrals, mandatory, obligatoire, and discrétionnaire. The classes of files that must come to the committee are prescribed in regulation. So they are set out, administrative action that affects finances, so forfeitures or deductions from pay, Canadian Armed Forces policies related to political activities, harassment, pay and allowances, and entitlement to medical dental care, and decisions of this where the CDS has made a personal decision. Ce sont des dossiers qui doivent.
These are the types of cases that have to be sent to us, but others are discretionary.
Where the chief has a decision to make based on whether he or she feels that there would be value at the committee and whether he or she feels we have the capacity. So that is completely discretionary. How they choose in between, I'm not entirely sure. But for the obligatoire, on les reçoit.
Those mandatory ones we get, but up until last year, the discretionary ones, we would get almost all of them. But this year, we've received far fewer. Okay, and on these discretionary files that are sent to you, the fact that they are discretionary, couldn't that in some way become a political tool? I'd like to hear your view on that. It could be the case in the sense that if someone has something to hide.
For me, it's, I guess I'm going to call it more in the workflow of the files and where the belief of efficiency lies. But as I've mentioned before, to ensure transparency and to ensure confidence in the system, it certainly would be much preferable that we get all the files.
Merci beaucoup.
Thank you very much. Mr. Lick, a few questions for you. On the details with respect to implementing your recommendations, I'd like to get back to that. There's no coercive way to impose follow-ups. How could this play out from a legislative standpoint? How could you impose a follow-up on the recommendations? And do you have any recommendations for the purposes of our report on that?
Yeah, in fact, in legislation, it could be, as with the Auditor General, in fact, their legislation, mandated timelines for responses are a way of making sure that the department does respond in a timely manner. I would come back, though, that that's one way that it could be imparted in legislation, but I would come back to the other part of it is that it doesn't mean that they have to accept those particular recommendations. But we are pretty good at at the work that we do and the recommendations that we put forward. The vast, vast majority are accepted. The implementation is just much slower than I think we would all like to see. But the other part of it is that the way that we impose transparency on the organization is we produce progress reports. Every year, those are updated by the department. We analyze the evidence and show whether the recommendation that's accepted has been fully implemented, partially implemented, or not implemented. That is all public. That's actually a best practice that I would like to see in the rest of the public service.
Merci beaucoup.
Thank you very much. And on the issue of timelines, as to the reports that you issue, and you were referring specifically to the mental health of reservists, 5 months, no response, would it be conceivable that the timeline for issuing a response would be set, and let's say the minister cannot respond within a time frame, that he would have to explain why he did not?
Yeah, exactly. And I think that, we're not naive. Sometimes it does take a longer time to analyze and assess the recommendation and so on. That's absolutely true. And so I would expect at least an acknowledgement of the report. I would expect at least if there's an issue with getting a response back in time that we would receive an explanation. We have received none.
Merci beaucoup.
Thank you very much. In the minute I have left, just before the committee we received a number of charts that refer to other ombudspeople in the federal government, and a comparison chart, actually. If you had to say you were a little bit jealous of anything anyone else has, what would that be?
So I think, as I think I've said a number of times, that legislation and the various pieces of the legislation would stop me from being compelled, stop my staff from being compelled, mandated timelines, as well as the ability to escalate beyond the political government and power to the national institution, Parliament, that represents all Canadians and represents the defence community. That would be the right thing to do. And then I think that those are kind of the three elements that I think are important. You can put all sorts of different things in the legislation. Every ombudsperson acts in a different way who has legislation. But I think those are kind of the three, I would say, principles that I would include in legislation.
Merci beaucoup.
Madame Matheson, 6 minutes, please.
Thank you both for attending today. Mr. Lick, when the Deputy Minister, Bill Matthews, appeared at this study, he said that he had loosened some of the financial controls related to the administration of her office. Was that the case?
No.
Have you experienced loosening of controls on the department's control of human resources in your office?
No, and that is in fact the area that is most problematic for our office, and we experience it almost every day. There are so many controls on our office that are, I would say, that are not appropriate. And not illegal by any means, but it's just not appropriate. One of the principles of ombudsmanry around the world is that we should be able to hire the people that we believe are best able to do the job. But there are so many HR controls on our office that we're not able to do that as best we think we should be able to do. I mean, Robin can actually provide you a current case in which now we have to redo a process because they made a mistake in one of their controls.
In terms of the controls related to that administration of your office, was that what your predecessor faced as well?
I believe actually that they faced different controls and different issues, and actually probably more severe than what we're experiencing now. But in essence, it still continues. It changes. One of the issues is that it changes from deputy minister to deputy minister. And that should not be the case unless there was a government-wide process or there was a particular issue that we were doing incorrectly. We are subject to the same controls as every other public servant, but where it's inappropriate is where those controls affect our ability to do our job in an independent manner.
When the minister came to this committee, I had asked about those Treasury Board cuts, and Mr. Kelly referenced them as well to Mr. Joshi. Can you confirm as well, Mr. Lick, whether your budget in any way or travel budgets or anything will be experiencing any of these cuts?
They have currently proposed cuts on on the travel and the contracting side of our budget. They have not been implemented yet because the new fiscal year has not been implemented, and we put forward our issues with it. I don't sit on the committees that look at these particular issues, and rightly so. We are an independent office, but in essence, we're not consulted in the same way that other senior leaders of the department are consulted. And that's problematic. I mean,
because that travel in itself, I mean, that's you going and visiting those complainants and seeing for yourself what is required.
That's correct.
Okay. So that will significantly impact the work that you can do.
I would say at this point the proposed cuts should not significantly cut into it, but we won't know sometimes until we get into it and find out that there are issues that we need to go and see. We need to go to a base to investigate a particular issue. These types of situations appear during the year. So we don't think at this point that the cuts will be problematic, but at the same time, the issue is again a perception of lack of independence, of interference.
Based on your experience, what changes need to be made to the administration of your offices?
Well, I do repeat myself a little bit, but I think legislation and the principles of that legislation that I put forward and just talked about, I think that is one way of doing it. I'm not saying that reporting to Parliament would make it any easier budget-wise, as other independent officers of Parliament experience, but I think the biggest thing that's due to our constituents, the people, the defence community that we represent, is that real independence and perception of independence is absolutely vital. The idea that the department is not interfering in the work that we do, whether it's through a travel cut or a contracting cut, but it's also that perception. But the other part of it I talked about earlier was that idea of confidentiality, that I and my staff in particular need to be protected from not being compelled to stand up in court and testify or in front of administrative process. That is vital to not only the independence of the office, but also that critical principle of confidentiality for our constituents, so that they feel comfortable and confident to come forward and tell us things that then we can look at.
So speaking to that, I mean, in 2021, I think you published a position paper titled "The Independent Civilian Oversight the Defense Community Deserves No Less." Can you table this paper with the committee today?
Absolutely.
Perfect. And I believe that that's a lot of what you're speaking to today as well. And then in your opening remarks, you talked about your retirement, and I know many of us are very sad to see you go. Has the government begun the process to replace you?
I do feel I have different feelings about leaving too as well. So I will say that just to start off. I've been looking at the assignment opportunities for my type of positions, GIC opportunities. I have not seen it there. I'm concerned at this point that July is not that far away, and a transparent process to select the best individual to represent the defense community in the work we've done has not started. I do not want to leave the organization in a place without an ombudsman, but there's nothing going. Where is it?
So they haven't, the government hasn't circulated like a job posting or anything like that. So what are the options? So would they just choose from a list of previous applicants, and what are the problems with that?
Well, I think there is no list as any public service selection process goes ahead. You have to say up front that you're going to create a list or a pool of individuals that you may use in the future. But that was 5 years ago, and there was no announcement like that. For me, I think the idea that, the selection process that I went through was very transparent. Anybody could apply. I think the same thing should occur going forward. It should not be selecting from a list that was never created before.
Thank you, Ms. Madsen. Before I turn it over to Ms. Gallant, you said something about stop you and your staff from being compelled. So I asked the analyst, what does he mean by that? We don't know. So if you could explain that to us.
Yeah, very, very simply is that, in certain processes like a board of inquiry that the military sometimes carries out, we have been asked to provide information on constituents that we may have investigated or helped with an investigation. We have not provided that information in the past, but I'm not legally protected from having to provide that information. As I said, I will fight it in court if I have to, but that should not be the case. Yes, it might have helped the Board of Inquiry, perhaps, but that principle of confidentiality that we adhere to is so critical for the confidence for people to come forward that I will protect it at no matter what cost.
Okay, thank you. That's helpful. Ms. Gallant, 5 minutes, please.
Thank you. And first to Mr. Joshi, can your department provide a response to a file within 45 days?
No, we're not able to do that, no.
Average time would be?
So the average time from receipt to dispatch of a file currently in the last year was about 16 months.
Okay. So missing information had been mentioned. Do you think this is intentional?
No, I don't think it's intentional. So in many cases, for example, it's a two-tiered process where there is a initial authority decision that's made first. After that, if it goes to the final authority, it comes to us. In many cases, the initial authorities do not get a decision out, so we don't get a file at all. We get the grievance with not a lot of background information. So that is one area of cases where we have missing information.
Do you have timely access to members' service numbers if it's not the person who is providing the grievance?
Sorry, I'm not sure I understand the question.
Okay, so if a grievance involves another member, how much time does it take for you to actually get the other member's service number?
We wouldn't get the service number.
Okay. Have there been any instances of reprisals from D&D or CAF superiors when a service member requested an ATIP?
For us, we wouldn't be we don't have any grievances of that nature. I've not seen grievances of that nature, but I can get back to the committee to take a look at it and see if we've had reprisal types of grievance for ATIPs. Our ATIP system is completely separate.
Okay. Are you aware of any situations where superiors went after members, enacted reprisals against members for bringing forth a grievance?
There are certainly instances where grievers have put in grievances about that subject, that I was aggrieved because I put in a grievance. Now the chain of command is mistreating me. We certainly do see grievances of that nature. They're not that common that we see them, but yes, we do see grievances of that nature.
Well, how should the service members be protected against reprisals?
Well, there are regulations that in place in the Queen's Regulations and Orders, but members should not have to fear reprisal or any bad things happening to them for putting in a grievance. It's their statutory right to do so.
And what are some of the challenges that members in D&D or CAF face when they want to blow the whistle, demonstrate wrongdoing?
It's certainly just as anybody else, the fear that the chain of command would take negative action against them in some way, shape, or form.
Okay, so very early on, when I got to Parliament, we had Andre Morin as the military ombudsman, and he was very capable and successful, I should say, in uncovering and getting to the bottom of the soldiers being exposed to different chemicals and getting compensation for that. So he seemed to be able to cut through at that time. Are there laws or regulations that have changed since then to make your job even more difficult to get to the bottom of a situation, to get the information you need?
I would say that, so when we're talking about, and as I said in my opening remarks, when we're talking about individual investigations, people come forward with a complaint or something, we are very, very, very successful in getting resolution for them. As I said, I think I might have mentioned our statistic is we're 100% successful at this point in getting resolution for them where we see unfairness in a process. What I'm concerned with more than anything is the ability to have responses on our systemic investigations, but probably more importantly, to have action on our systemic investigations more than anything. And that can involve any sorts of circumstances, different constituents, whatever it might be. That is probably where my biggest concern is at this point in time.
Were there any instances where D&D or CAF tried to interfere with your duties as an ombudsman, specifically in regards to complaints to D&D or CAF superiors from some subordinates?
I would say at this point, in my experience, and perhaps Robin can supplement with her previous experience, I have not seen anything at this point that would suggest that there's been anything inappropriate in terms of interference on an individual complaint. Sometimes it takes us a little bit of time to get some information. Sometimes it might be classified. But we generally find the CAF actually very cooperative when we ask for information. I always say that when we call, when the investigators call, the people on the other end of the phone line sit up straighter. It's just an idea that they actually do respond actually pretty well.
Mr. Collins, 5 minutes, please.
Thanks, Mr. Chair, and welcome to our witnesses. Mr. Joshi, can I ask you in terms of the many of the questions at our meeting today and past meetings centered around, the number of grievances and then the process a grievance takes after it's been filed by a CAF member. I'm interested in the conflict resolution process that you have in place prior to someone filing a formal grievance, and how that process might help us reduce the number of grievances that we have. And so could you relate to the committee in terms of what process is in place to a member who has an inquiry about a personal matter that they have and they're contemplating filing a grievance?
So we are not a grievance. We only see a grievance when it's referred to us by the Canadian Forces, which is long after the grievance has been filed. Usually it's going to be 4 to 6 months at least after it's filed. What we do keep on our website, we publish case summaries, and those, if an individual calls us, we could direct them to our website with case summaries so they could have an idea of what types of findings and recommendations have been provided in the past. When final decisions are made by the Chief of Defence Staff, we also summarize those and add them into our case summary batch so that a griever could see, in essence, how the Canadian Forces may have looked at it. But in terms of us engaging in conflict resolution early on in the process, that is not part of our mandate.
So they would then turn to the complaint management service that's offered? Is that?
That is correct.
Okay.
Yes.
I know that in dealing with, there are a lot of similarities with the collective bargaining process and unions as it relates to their rights that they have. And of course, our system here is managed differently under the Act. The question that I have is in terms of, I found over the years in terms of dealing with employee grievances that oftentimes it's a leadership issue. It is one where I could look back in the career that I had prior to this one, I could look back at individuals who, wherever they went in the organization, we'd see a bump in the number of grievances. And that just seemed to be a trend that followed with them. And I think a lot of that had to do with leadership skills and interpersonal skills and how they dealt with, in this instance, employees. Can I ask you, Mr. Lick, in terms of how much of it is an issue related to culture and leadership as it relates to the ballooning number of grievances that we've seen? Conversely, then, how much is it related to the cultural change that we want to see within the organization?
I think there's likely a whole range of reasons why people put in grievances or complaints in our case. And, I think, yes, absolutely, some of it has to do with leadership, but the ability to resolve conflict in a workplace. That doesn't always mean that it's leadership. Sometimes it's with your colleague and so on. So absolutely the ability to deal effectively with interpersonal relations, that is absolutely a skill and a lack of skill that actually results in complaints and grievances. But I would say that the department is putting in place some means of helping people deal with that through the CCMS group which helps individuals deal with conflict in the workplace. A great initiative. In fact, we refer people back and forth between our group and theirs, depending on who's best able to handle a particular complaint. The informal conflict resolution process that you spoke about, I think, is new in terms for the CAF at this point in time in the grievance process. I think we're optimistic that it will provide another opportunity to resolve a complaint or a conflict before getting into the long process of a grievance. So we're optimistic, and I think it will be a positive thing. We just don't see all the results just yet because it is so new.
Right. Follow up on that is you talked about the mandatory timelines and the benefits that come with that as it relates to resolving grievances and complaints. And I know that, again, dealing with unionized employees, the big issue there is it becomes a morale issue, right? The longer it festers and boils, it can also lead to other grievances. Can you speak to some of the morale issues that have come about as a result of some of the investigations that you've undertaken in your office in terms of their impact on, yeah?
So I think, as I said, we're very effective at getting resolution for people that come to us. But we can only really help people resolve an issue if they do come to us, other than through some of the systemic investigations we do. But on an individual basis, though, yes, we're very successful. But we always say to people, as I think I mentioned earlier, if you can come to us earlier, we may be able to help you earlier, whether that's with information or helping you deal with a particular issue. Sometimes it's a simple phone call to somebody we know in our great network of contacts. But the idea but some people sometimes leave it to the last minute to come to us, and that's usually not that helpful. We can still help them, hopefully, but we say to people, yes, we're the office of last resort, but we're also that office of first resort too as well that helps people deal with an issue, hopefully before it becomes an issue in the first place.
Thank you, Mr. Collins. Before I turn over the 2.5 minutes to Ms. Normandine, I'm taking note that all of the noise in this room seems to come from one location. I've yet quite to determine it, but I got an idea. So I might mention that the next time the noise level hits. So respect for colleagues, please. 2.5 minutes, Madame Normandine.
Merci beaucoup.
Thank you very much. Mr. Lick, in the documents we received from you, something drew my attention. The fact that in the UK, the Ombudsman can not only make recommendations, but in some cases, they are binding. So I'd like to hear if you have any information on the kinds of recommendations could be binding there, if that's something that could apply to you. And to get back to Mr. Joshi, as to whether that might be conceivable within MGIRC to have these types of binding recommendations.
So yes, the UK Ombudsman, the Service Complaints Ombudsman there, it does have the ability to, in essence, enforce certain recommendations, not all, but certain recommendations. That is one way of doing it. I think we've proven ourselves, and with the CAF in particular, that we were able to do that without that type of enforcement. So I'm kind of neutral as to whether that would be beneficial or not. I think the idea, usually with most ombudspersons around the world, there is no enforcement power generally. And that's because of the way that ombudsmen work through moral suasion. Do the right thing with the evidence of our investigation. And like I said, generally we find with individual complaints that works quite well for us. So I don't think it's absolutely necessary. There may be a situation in the future that it may be nice to have, but I would say that it's not absolutely necessary with the situation that we're currently in. At the same time, that situation could change with different leadership and so on. So I'm kind of neutral on that in that way.
Peut-être, Monsieur.
Mr. Joshi?
Possible? Yes, it is possible. Mr. Fish made 2 recommendations in that regard, that if the final authority does not make a decision in 90 days after receiving the file from us, our findings and recommendations would be binding on the Canadian Forces. And the second scenario, he called for a working group to look at whether the final authority power should be directed somewhere else, somewhere like the committee. I would just caution that it's not as easy as it may seem, because the authority set must follow, that if we are giving decisions with a financial implication or putting people in certain positions, the authority set must be there, but it is certainly something that could be investigated, and Mr. Justice Fish in his 3rd IRA report did make those recommendations.
Thank you, Madame Normandine. 2.5 minutes, Ms. Madsen.
Yeah, I think to build off of Madame Nobrandin's questions, I mean, I spoke to, when the minister was here at committee, and I asked directly whether those pieces of independence, especially around the ombudsperson and their office that I was calling for in legislation, my bill C-362, if that would be made within the changes that he has indicated he will be making. Unfortunately, he said that they were not. So I'd love your comments on that. But Mr. Joshi as well, I mean, you talked and referenced that independence of, and the importance of the independence in your office, and the changes that Justice Fish and Justice Arbour were asking for as well. Do you believe that those will come forward in future legislative changes? Have you heard anything? How important are both of those for both of your offices?
So I'll start first, if I may. Yeah, certainly the minister has not consulted with me on that particular legislation, so it's kind of hard to say what exactly it is, though I have some knowledge maybe of perhaps what it could be. But certainly he has not consulted with me on that, on the issue of independence of our office. You know, that I think is unfortunate in the sense that I think it's appropriate that I put a case forward and he can decide what to do with it, obviously. I'm obviously, you know, my opinion on whether and all my predecessors' opinion on whether we should be legislated or not. But at the same time, I think ultimately it is a choice of Parliament as to whether this happens or not. And I think the best opportunity is going forward with legislation, absolutely.
Mr. Joshi.
With the grievance system, we know that the Canadian Armed Forces is making internal adjustments to their system. We've been briefed on some of the amendments to the system, but there has been no discussion on their part, with us at least, of looking at those two critical fish recommendations.
Thank you.
You've got 30 seconds, but
It's fine.
thank you.
Thank you.
Mr. Bazan, 5 minutes.
Thank you, Mr. Chair, and I want to thank both witnesses, or all three witnesses, for being here today. Mr. Lick, can you just remind me, did your predecessor, Gary Walburn, actually propose legislation, enabling legislation to make the office of the Ombudsman independent and as a office of Parliament?
Yes, in the document that we'll table with the committee, yes, it does have draft legislation in there for the independence of the office through legislation.
Okay, and that would then, if you're looking at making sure that you are truly independent, and when we look at a historical case here, and going on Mr. Collins' line of lack of leadership, we know that with the sexual misconduct case against former Chief of Defence Staff John Vance, that documents by your predecessor was given to the Minister of National Defence at the time, Minister Sagen, who refused to handle that documentation. As an independent office, how would that situation have been handled?
Well, I'd say it would be difficult to understand how it would be handled without having all the details in it. If it was a criminal matter, we would still be prevented from, we would make sure it gets to the right place to be able to deal with that, whether that's with the military police or whatever. With that particular instance, while I don't have all the details, obviously, I think it's a matter we can put in legislation how would I escalate it? Would I escalate it to the Prime Minister? Beyond the minister, if I'm not getting action on it? Would I escalate it to this committee? There's a variety of ways that we could do it for the different situations that we might encounter. My point is that it should be escalated to someone who can take action on it that is apolitical or not political.
But at least you'd be able to get action on it.
Yes.
And you wouldn't have the cover-up that we witnessed under the previous Minister of Defence. I appreciate that. Now, when we start looking at your budget, and you're saying there's cuts coming, those are a unilateral decision that's being made by the Minister of National Defence, that you don't even have any input in saying this is what our budget is, this is what our needs are. They're just going to give you the budget and you have to make do with what you get?
Yeah, certainly they've proposed cuts on our organization. We do have the ability through the business planning process to say what the impact would be and type of thing. But generally those cuts, the decision on those cuts at the very end is not mine. The decision is the department's.
So you're saying it's going to impact on your travel, being able to go across the bases, meet with members of National Defence, members of the Canadian Armed Forces, and you also said contracts. The contracts you're talking about would be having those types of specialized inspectors or investigators?
It could be, yes, if it's a contract for professional, generally a contract for professional services. So that could be hiring, as we have done, a team or an organization that would help with research, as we do right now. It could be something as simple as IT support. It could be a variety of things. It doesn't really matter. One of the things that we will likely have problems going forward is our IT system. And we don't have the experience in-house to be able to do that.
So you're done July 2nd. Do you know whether or not there's been anyone appointed or somebody is in the works of being vetted to replace you as ombudsman?
No, we do not.
And we have a similar problem over at MGIRC, that you don't have a permanent chair or a vice chair at this time, and no indication that anyone is being appointed to fill in?
Vice Chair was appointed last week. We got notice of the OIC last week with a start date in April. With respect to a permanent chair, we understand that it's in the works, could expect something very soon, but I do not have a date for that.
So foot dragging on appointments are impacting upon the ability to get work done, and who knows what's going to happen going forward on the Ombudsman's office if they don't extend your contract. So let's talk about the CDS referring cases over to the Military Grievance Committee. Does the CDS just cherry pick these, or is it escalated by some other means?
So for the mandatory grievances, no choice in the matter. If it fits into a subject category, mandatorily comes over to us. For discretionary files, we have no visibility on the criteria that are being used. Up until very recently, we received almost all discretionary files, but as of last year, the number of discretionary files we receive has gone down significantly.
Okay. You know, you say it takes 16 months to do one of your reviews and to report back to the CDS. ATIP takes, by law, is 45 days. If ATIPs were actually handled in a transparent manner and getting back from the Department of National Defense Canadian Forces to the members or to those that are asking this, for this information, whether it's privacy or just extra information, would there be as big a backlog facing your committee in dealing with those grievances?
So the ATIP does not affect us at all. We come outside of it, but if a time limit was put in place, absolutely it would have an impact for getting back the information. Absolutely would have an impact.
Thank you, Mr. Bazan. Mr. Fillmore, final 5 minutes.
Thank you, Chair, and thank you, witnesses, for your work and for your time today. I want to switch gears a little bit. There are many facets to the question that the committee is studying. The facet of it that I'm interested in is the information, the data, and how it moves and how it's accessed. There was a 2020 paper by the Office of the Information Commissioner of Canada that talked about options for establishing a declassification strategy for documents to do with national security and intelligence records. And my question to whomever would like to think about it with us is, would an automatic declassification regime be beneficial in the work of in your work as it pertains to DND and CAF records?
I think for my purpose, we very rarely deal in classified information. Most of the information we deal with is protected B type of thing. So, you know, that particular issue of having a way of declassifying information and with regards to the Information Commissioner, I don't think would affect us in any material means.
Mr. Joshi, does having access to classified or getting documents declassified aid you in the work of the GIRC in any way?
Very similarly to the Ombudsman's position, it would have very little impact. And in fact, there's an obligation under the National Defense Act for the Chief of Defense Staff to provide to us all relevant information. And of course, it behooves a griever to provide us all relevant information also if they want us to consider their grievance fully.
Okay. Well, staying with this, thank you for that. Staying with this theme of data and information, it was brought up at a previous committee meeting on this topic, on this study, that we live in the modern era, and the preponderance of data that comes with that is pretty vast. Whereas a grievance might have involved walking down a hallway in 1980 and opening some file drawers and finding some papers. Now there's a great deal of searching for electronic records and so forth. Do you think that the preponderance of electronic information and data is linked in any way, even in the smallest of ways, to the length of time, the timelines that we're talking about now to fulfill the request for information?
In fact, for us, I think it speeds it up because the search for us is a little bit more efficient than having to look through all the paper files to find the information, and how we can store it and access it also within the committee is enhanced by having it electronically.
Anything from your office?
No, I think searching through paper boxes and boxes of paper files was a pretty inefficient way of finding information. With our investigations, typically the issue is sometimes it's time issues in getting the information from the department. They have to search through the information. Sometimes it's an issue of getting the information from the complainant too as well. Hard to get a hold of them and things like that. So it's on both sides.
Okay. So I'm thinking a lot about the infrastructure with which the federal government moves data, moves information. I mean, we know that there's a lot of information out there, records that need to be accessed, and sometimes I wonder if we overlook the train tracks that this information has to move on. And I wonder if you have any, thinking about it maybe through a lens of modernization of systems, any reflections on that as it pertains to your work?
Well, certainly we, as I said, we need to update and modernize our IT system, just as any IT system needs to be updated over time. The department in our case has zero access to the information we store in our IT servers. That's really important for the confidentiality principle that we work under, but it does need to be modernized, absolutely.
Okay, thank you. Maybe moving on from that 1 minute, just, well, it's hard to fit this in, but for you, Mr. Ombudsman, what is the greatest way that the ATIP process impacts your work?
The ATIP process, which we follow the law in essence, so we don't get as many ATIPs as the whole department gets, absolutely not. But we follow the law. We're very, very good at getting the information for an ATIP request. We're actually pretty good type of thing. So it doesn't truly affect us. It does change year to year, though. So we never know from year to year how many requests we might get. And so we do have a contract, professional service contract in place. It's sort of like a retainer that if we need to have additional resources for that big year, then we will access it too as well.
Okay. Thank you very much.
Thank you, Mr. Fillmore and Mr. Lick and Mr. Josie and Madame Hines. I want to thank you on behalf of the committee. Your contributions to our study is quite valuable, I'm sure. With that, we'll suspend and re-empanel. Meeting suspended. pretty good. This is for our second hour. We have Carolyn Menard, Information Commissioner, Alison Knight, Senior Director of Investigations, Priority Cases, Historical and Intelligence, Office of the Information Commissioner. Priority Cases, well, that's quite a long title. And Harriet Soloway, Public Sector Integrity Commissioner, and Brian Radford, General Counsel. So welcome all to the committee, and I'll just ask you to go with your first 5 minutes in sequence. So Ms. Menard, 5 minutes, please.
Merci beaucoup. Je vous remercie de m'avoir.
Thank you for inviting me to speak to this committee. Since this is my first appearance before your committee, I would like to give you an overview of my mandate as Canada's Information Commissioner. To understand my mandate, it's important to recognize that I am an independent agent of Parliament whose role is defined under the Access to Information Act.
Information Act provides a right of access to information in accordance with the following principles: that government information should be made available to the public, that necessary exceptions to the right of access should be limited and specific, and that decisions on disclosure of government information should be reviewed independently of government. The Treasury Board Secretariat holds the overall responsibility of administrating the Act. This includes providing guidance and tools to government institutions. Access to information requests can be made for any records under the control of a government institution. About 260 institutions are subject to the Act, including the Department of National Defense. Les institutions sont tenues de répondre aux
Each institution is responsible for responding to the access to information requests it receives. My role as Information Commissioner is to investigate complaints relating to those requests. Complaints are submitted to my office when requesters are not satisfied with the amount of time that it is taking for an institution to respond, or if they believe that they have not received all of the information to which they are entitled.
So far, this current fiscal year, I have registered 103 complaints against the Department of National Defense. As of today, the department ranks 6th in terms of the number of complaints received by my office. At the conclusion of an investigation, I have the power to issue an order against the institution, including ordering the disclosure of information to the requesters. My orders are legally binding. When institutions receive an order, they must implement the order unless they apply to the federal court for a review. This year, I have issued orders in 29 investigations against the Department of National Defense, mainly on timeliness of responses to access requests. In several of these investigations, I found that it was a lack of responsiveness from teams responsible for providing records that affected the department's ability to meet its obligation under the Act. Comme je l'ai souvent souligné dans des déclarations,
As I have often noted in statements on the importance of transparency within the federal government, senior leadership that is key to influencing corporate culture change. This leadership must extend to information management practices and internal communications protocols in order to ensure compliance with the Act.
give you an update on recent investigations I concluded against the Department of National Defense. Last June, I ordered the Minister of National Defense to release records on its COVID-19 policies by November 30th, 2023. These policies were requested through an access to information request made the year before. The department told my office it would comply with the order. However, it did not meet the November deadline. This is why last December, I filed an application for a writ of mandamus to compel the Minister of National Defense to comply with my order. This was the second time I had to make this type of application as a result of an institution ignoring my orders. Last week, I filed 2 new applications to compel the Minister of National Defense to comply with orders that should have been respected in November and December of 2023. These files are currently ongoing with the federal court. As such, I cannot discuss the particulars of these proceedings. However, I can tell you that this type of extraordinary recourse to compel an institution to respect orders should not be required. It raises doubts about my authority and, more importantly, the credibility of the access to information system of the federal government. I will now be happy to answer your questions.
Thank you, Ms. Menard. Ms. Holloway, 5 minutes, please.
Bonjour, Monsieur le Président.
Good day, Chair. I'm pleased to provide some information to your committee as to the current scheme that exists within the public service. The Office of the Public Sector Integrity Commissioner was established pursuant to legislation by the federal government with respect to accountability. The office provides a confidential system allowing for public servants and members of the public to disclose wrongdoings within the federal public service. It should be noted that legislation specifically defines what would be considered wrongdoing, a definition that does not include all manner of wrongdoing in a general sense. The Act provides that current public servants and ex-public servants can table complaints with respect to reprisal relating to disclosures. As an officer of Parliament, I exercise a function that guarantees independence and a neutral stance. The Commissioner cannot launch an investigation with respect to the Department of National Defense, the Communications Security Establishment, or the RCMP. These organizations, or rather CSIS, these organizations need to maintain their own internal systems. The Commissioner is, however, enabled to launch investigations on disclosures with respect to the Department of National Defense and on complaints tabled by officials that work within the department or previously did. The legislation also provides that federal organizations that are subject to it shall implement internal processes, which we call internal regimes, and these organizations have to designate an officer for disclosures and have this person have the same mandate that reflects the commissioners. The secretary, the Treasury Board Secretariat is responsible for administration, and pursuant to the Act, public servants can make a disclosure to their superior or supervisor through the internal mechanism within each organization, or contact the commissioner directly in the context of the external scheme. That is their choice.
Establishes standardized processes for handling disclosures and reprisal complaints, including service standards for various stages in the process and clear policies to support decision-making. These internal processes are intended to ensure the consistent and fair treatment of cases. They are reviewed on an ongoing basis and are periodically amended to optimize efficiencies. Any individual may make a confidential disclosure of wrongdoing to my office by submitting a form online, via fax, by mail, or in person. Once received, disclosures are analyzed to determine if they fall under my jurisdiction and whether allegations could constitute wrongdoing as defined in the Act. Analysts may reach out to the disclosure for further information during this time. In cases where I do not launch an investigation, the disclosure is informed in writing of the reasons for my decision, and the matter is closed. In cases where additional significant information becomes available, I may reconsider that decision. In cases where I decide to launch an investigation, the deputy head of the affected organization is contacted as well as the disclosure and the alleged wrongdoer, and the investigation begins. We have a service standard for completion of investigations within 12 months. Investigations can include interviews with witnesses and the alleged wrongdoer, as well as the collection and examination of documents or other evidence. Throughout the process, my office respects the right of procedural fairness and natural justice for all involved parties. Après une enquête, je conclus.
Following an investigation, I find whether there has been wrongdoing or not on the preponderance of evidence. In the case of wrongdoing, I have 60 days to table before Parliament a report where I describe the act in question. The report also includes my recommendations for corrective action, as well as a response from the General Administrator to these statements. To date, my predecessors have tabled 19 such things. I have been in this position for less than 5 months, to note. I recognize the difficulty in making disclosure, and I take seriously the importance of maintaining confidentiality for disclosures of wrongdoings. The same thing applies within departments. The Commissioner never shares the identity of the person disclosing, but this individual can be the subject of reprisals if identity is disclosed in other manners. The individual can table a complaint before the Commissioner. The processing of complaints is similar to that for disclosures, but under the Act,
Conciliation and mediation are important tools to optimize outcome for the parties, and we have thus far funded 24 successful conciliations, and I thank you for your time.
Thank you. Mr. Kelly will start our 6-minute round.
Thank you, and Commissioner Maynard, thank you for clarifying some of the things that in your opening statement. 2 weeks ago at this committee, Minister Blair said that he didn't believe that the matter of the ATIP compliance and the litigation that has resulted arose from his department. So I thank you for some clarity around that. And can you confirm for the record then that the title of the case is actually the Information Commissioner of Canada versus the Minister of National Defence?
In 3 cases, yes.
Okay, thanks. In 3 cases now. So thank you for bringing that to our attention. So since we had the minister here 2 weeks ago, you have 2 more refusals from his department, and you are taking him to court now over 2 other refusals.
That's correct.
Okay, can you give us, I understand that you are not able to talk about the case itself or the merits of the case, but can you give us some timelines and what communication or information you were given around their refusal to comply with your orders?
It's not so much as a refusal. I think they're incapable of respecting the orders because of the lack of resources and the lack of responsiveness from the different sections of national defense where the records are held. So there's an issue there. Within our investigation, we found out, and then we realized that when we issued orders, they're still incapable to get that information out. So we have to go to court now to make sure that that is respected.
Okay, when did you make the orders in the 2 new cases?
Alison, do you have that information? I know that the date of the orders were to issue the information by November and December. The date of the orders themselves, it would have been in the summer because they usually have 36 days, business days, to comply with an order.
Okay, so did they inform you that they were incapable of fulfilling the order, the lawful order that you gave them?
So,
did they tell you that they were incapable, or did they just let the clock run out, or did they make excuses over willingness?
When we issue an order, we have to give them an intent to order, so they have 30 days to respond to us as whether or not they're going to comply or take us to court. In all these 3 cases, they told us they were going to comply with the order, and we found out through information, often it's the complainants that reach out, that it was not met, the date has passed, and that way we have to go to court to make sure that the order is respected.
Okay, I'll ask you the same question I asked the minister. Is this openness and transparency at work, and a demonstration of openness and transparency for Canadians, per the 2015 promise that this government made?
It's definitely affecting the credibility of the access to information system.
Okay, so how does that affect people that need information from the department? And we have reports of people who are facing, are trying to register their complaints of harassment, sexual misconduct. They need access to information to be able to make their complaint, and are not able to get information. What does this say to people that need information from the department?
I can't talk about privacy access because the privacy commissioner would be the proper person to talk to about complaints for privacy requests. I suspect that they have the same problem in responding to these type of requests. We see definitely that our complaints are related to timelines. The department has been getting worse as we speak. The last three years, complaints have been increasing. It's usually about timelines not being respected.
Okay, and again, what reasons do they give for not meeting the timelines?
The reasons that we find during our investigations are mainly with respect to we call them the OPIs, the Office of Primary Interests, where the records are. The unit at the ATIP unit is asking for those documents, the information, and they don't receive that information.
Okay. In respect to some of the recommendations from your last report, the government takes note of your recommendations, which is what is that? Is that code for we reject your recommendations?
You're talking about the systemic investigations, the report
Yes.
that I did in 2018. National Defense definitely had some issues in treating and answering requests at the time as well. We did a systemic investigation. We issued 9 recommendations. Since then, the department has put in place a management plan to respond. It hasn't been really good the first 2 years, I have to say. The complaints has reduced in 2019 and 20, but since then it has gone up. And like I say, I think leadership has a big role to play. The department is not responding to the request.
Thank you. I am just about out of time, and I actually was referring to the committee, the ethics committee made a set of recommendations in 2022, and that was one in which the minister had explicitly sort of said that we note the recommendations but aren't implementing them. And the one that was specific was about recommendation number 7 of the ethics committee was an expedited access to information system for victims of military misconduct, which they are not, they did not accept and are implementing, as far as I understand. Do you have any further comment about that recommendation?
This report was sent to the Treasury Board Secretariat, and the Minister of the Treasury Board President, as you said, responded that they were going to be looking into it, and there's no recommendation that was actually implemented.
None implemented.
Okay. Ms. Lalonde, 6 minutes.
Merci beaucoup à nos témoins.
Thank you very much to our witnesses today. It's really a pleasure to have you here.
I guess la première question que
My first question is for Madame Ménard. With respect to that you have as commissioner, that you publish within a database and on an internet site your decisions, and I see that we can look at this database, and there's an increase in the number of decisions with respect to the department in respect to its a tardy reply. You referred to 2021, so in 1919 and 20 things were okay, but in 21 there was some lagging behind. Would you be able to address perhaps why we had this increase after 2021, what could explain it? And something did happen in 2020. Of course, I think everyone knows everything was shut down for quite a while, the pandemic. Do you think this had an effect on the number of decisions rendered? the pandemic certainly had an effect on all institutions in terms of them upholding their side of their obligations. National defense during the pandemic was actually exemplary in the sense that they took many measures in 2020. Actually, it was interesting. In 2021 and 2022, that's when we see an increase in the number of complaints. So the impact of the pandemic has a knock-on effect on the following years, and these timelines keep increasing. So we can no longer use the pandemic or COVID as an excuse to explain these tardy replies. As I was saying earlier, the main reason at National Defense is that the units that hold this information are not responding within that 30-day period.
Because so maybe either what would you recommend? And one of the things in our last committee meeting, one of the witness actually brought in a perspective that 30 days may be not realistic, like it's just not. And there was suggestions by this witness, this person that came, that maybe we should look at expanding. Instead of 30 days, let's make it longer. So hopefully, I would really like to hear from yourself, Madame Ménard, and maybe Madame Soloway, your perspective on that. Merci.
Ms. Soloway,
Based on Treasury Board statistics, I think 60% do respect that 30 days, but in a general sense, it might be at about 50% about 50% of them are late. If you provide extensions, of course, if you give people 60 days, then people will use the entire 60 days to then ask for additional time. So what you need to look at is all the factors that lead to these deadlines passing. And someone was referring to information management. Yes, there's way too much information, and people are not managing their information well. And when there's an access to information request today, it's not just 2 or 3 pages within a paper document. We're talking about thousands and thousands of pages that are requested that people have kept to explain a decision.
information management, and that causes delays. The consultation between departments causes delays. Something has to be done with respect to giving a timeline to institutions that are receiving consultation requests to shorten those delays as well. And that's one of the recommendations I made in my submission to Treasury Board with respect to the legislation.
I would like to hear your perspective on.
Insofar as the act under which we operate is concerned, I don't think that we've had a problem with a systemic problem with the disrespect for the delays that the act imposes. I will just hand over to Brian Radford to expand on it.
Thank you. Madame Soloway is correct that we have not seen this issue raised with us to any significant degree. With respect to our own Commissioner's office, we're a very small entity of 36 people with a single mandate to implement the PSDPA, the Public Servants Disclosure Protection Act, which means that it might be a bit easier for us to meet the 30 days when we are faced with an access to information. We have, of course, certain exemptions with respect to our disclosure information.
And I may have a few minutes left. I know that during your time you couldn't finish everything. Is there a perspective that you would like to bring forward to our committee?
Thank you for the opportunity. I actually was pretty close to the end. I was just going to mention some of the process about referring cases of reprisal to the tribunal, but for the most part, everything was touched upon. Thank you.
Madame Normandin, 6 minutes.
Thank you to the witnesses. I have questions for both of you. To start, Madame Ménard, I understand the Ethics Committee here issued some recommendations with respect to the Information Commissioner potentially being able to issue some monetary penalties for a lack of for not upholding these orders that you issue. And I think you had writs of mandamus that you had to also turn to. Would it be a deterrent if there were penalties fees and fines, etc. Why did we have to get to the point of writs of mandamus to get here? As to the orders, one of the processes that I recommended at the time when Bill C-58 was being looked at was a process for approval of the recommendations issued by the commissioner. So you have to go before the federal court so that your orders are upheld in the same way that they would be for court orders. It's a much easier process than a writ of mandamus. At the time, the government had said that we didn't need that type of process, but because the government was going to respect these orders and these orders have force of law, and now we can show actually that that's not exactly the case. So an approval process would be sufficient for institutions not to want to be found in contempt, if you will, of court. As for these penalties you're referring to, people always ask us who should be punished when the department doesn't reply or doesn't respect the act. It would be very difficult, as far as I'm concerned, to create a system that would sanction a senior official. But I think having a process in place for performance assessments as to people's performance when in their response, in the ways that they respond to these access information requests, when it affects bonuses and affects remuneration, that might go a little further. As they say, money talks. So I'd like to hear you on this issue of money. I understand that you've asked for $6 million additional dollars over 3 years to be able to complete your processing of complaints. That's actually twice the number of complaints that you usually would have in comparison with your budget. Where do things stand? That's an application that's going through a process, the current process that exists in order to ask for additional budgets. I have had no follow-ups, neither from the Department of Justice or the Minister of Justice nor from Finance. So I don't carry much hope for additional funding. It's unfortunate because I'm an independent officer of Parliament, but I do have to report to those departments to get additional funding in order to accomplish my task or under my mandate. This year, thankfully, we've received fewer complaints, so we're able to reply or respond, but my inventory is actually not dropping because I have as many inputs as outputs. Certainly, we would need a way of accessing funding when we need it in order to meet the requests or to hand money back if there is a decrease in the requests. But that should be independent of government. Thank you. I have other questions for you a little bit later, but I'd like to hear from our other witness. Madam Soloway, last September we received information according to which the Department of National Defence had breached the Disclosure Protection Act, and there had been some comments as to the fact that it was troubling. Within the internal process, the department hadn't even updated its own website to indicate that there had been investigations underway. And actually, the whistleblowers weren't even made aware of the results of these requests. I'd like to hear what you have to say as to the role that your institution has in parallel with the internal investigations, in the sense that I understand a whistleblower can turn to one or the other system internally or on your side. But if there is a lack of confidence to proceed internally, what effect does that have on your organization? Does that not increase over the last few years the numbers of applications that go through you rather than internally?
Without commenting on the reason why, because I haven't done a full analysis, there's no question that our office has been seeing a consistent increasing caseload. I stand to be corrected, but I believe that we're approximately 50% over last year, and I believe that the year before there was an increase. Our office, in speaking about budgets, our office has not had an increase in budget since it was established in 2007. And so, we did put in, I was in the job 2 weeks, and, at the time when we had to submit a budget request, so we did make some very, very modest requests for an increase in budget in the coming budget year, primarily because our IT system is about to collapse. But we are now taking stock of where we are and what we need with a view to looking at how we can best be structured to increase efficiencies, but also to identify resources that we're going to need going forward based on this strong trend analysis that we've done. So we share a concern that I know other agents of parliament share, but in our case, it's quite acute. We do have a concern for the budgets going forward. I don't know whether that responds to your question.
Thank you for that
Thank you.
response. Madame Matheson, 6 minutes, please.
Thank you. Since 2007, that's horrific. You said your IT system is about to collapse. Can you just go into more detail, like what?
Well, we've just up until several months ago, and Brian has the institutional memory here, but up until several months ago, our IT services were contracted out. So now we've moved toward an in-house capability. We have 2 people in-house, and they're keeping the system together for right now. We've already requested equipment that we were able to do in this budget year. So we expect that quite shortly will be upgraded.
And you want to
right
keep
now,
that in-house?
I
Going
think
forward.
at this point we have to keep it in-house for a whole host of reasons that I won't go into, but are in our budget submission. If you'd like me to expand, I can.
Well, I would assume that's because it's also more affordable.
It's more affordable, it's more secure in terms of, so for a number of reasons, yes, affordable and secure. Yeah.
For both of you, both commissioners, throughout this study we've heard a lot about the differences between the officers of Parliament, being commissioner, being the ombudsman. We just heard from the ombudsman, and I'm particularly interested in the independence of those offices. Do you believe that could you talk to us more about that independence and how your roles as commissioners and the independence of your roles allow you to do what you do, and the importance of extending that maybe to the role of an ombudsman?
Thank you. It's interesting because I was at the MGRC in 2011, and the same issues or the same, I was listening to Mr. V.R. Joshi, and it hasn't changed that much. Same thing for the ombudsman. But as an agent of Parliament, the good news is we are reporting to parliaments, and we are completely independent from any. The resource issue is the only thing that really affects us. It really has an impact on whether or not we have the resources to fulfill our mandate. But apart from that, I am investigating the Minister of National Defense. I am investigating the Justice Minister, the Finance Minister, Treasury Board. So we are, and we are reporting to Parliament the results of our investigations. But without the proper resources, the proper mechanism to get the resources, it is impacting our ability to do more. I have 87% of my salary, of my budget is salary. And I'm like Commissioner Soloway. I have an IT team that's super small. We can't go to the cloud. We can't do things that that other big departments can do quickly, because I want to do more investigation. I want to reduce my timelines. I want to be more efficient in the mandate that I've been given. So we have to make choices where the money is going to go. And those are difficult. And as an ombudsman, I'm sure reporting to a minister, it's not the same thing. Like when you have decisions being made by a department, you responsible for that, where we have complete separate mandate.
Just to add to that, I think because both of our organizations are so small, and I don't mean to speak on your behalf, one of the challenges that we have is contingency funding for either sharp increases or sharp bumps that may or may not be sustained, or for complex cases that may arise, out of the ordinary, or in cases where there may be a need to finance or fund, legal services for judicial review. These are things that are hard to budget for. We have to keep money aside for that in case it happens, which impedes us from using the money operationally on a day-to-day basis, because we have to be prepared for any eventuality. When you're in a larger organization, you can move things around a little bit more easily, but for us, it's a little bit challenging. But otherwise, I absolutely concur with my colleague.
The deputy minister, in a meeting on this study, he talked about that digitization being quite a large fix for this problem. Would you agree with that? And are you seeing that happen in the departments satisfactorily?
Sure. It's certainly one piece of the puzzle. I wouldn't say that the majority of the cases are impacted by a digitization problem. I mean, that largely goes to historical records that are still in paper. It's not like the military is working on paper today. So if you're looking for contemporary records, I don't think that is the main barrier to the timeliness issue.
Okay. How much time do I have, Mr. Chair? 30 seconds. I'll wait. Thank you.
Thank you. Colleagues, we're supposed to rise at 1:06, I'm told. We got not nearly that amount of time for 25 minutes worth of questions, so I take a minute off Mr. Bazan's question and keep on going.
Thank you, Mr. Chair, and I want to thank both witnesses for being here. So, Commissioner Maynard, very compelling testimony you've given us today. How many other departments other than National Defense have you been forced to take to court?
Only one. It was TMC.
Okay. And just on one case?
Yeah.
And so in the time that you've been commissioner since 2018 or before, how many times have you had to do this?
It's the first, well, first of all, the authority to issue orders has only started in 2019, so it took us about maybe a year or two to start having files where we issued orders. We're seeing an increasing number of orders. This year I've issued 298, something like that. And then all of a sudden, most of the time institutions are complying, or they go to court to contest the orders, which is what the Act allows. But in 3 cases now, 2 against National Defense and 1 against TMC, I had to issue or ask for a mandamus to force the institution to respect the order.
So in you also said that this is undermining your authority and undermining the Access to Information Act. And so for a government that says that they are going to bring more transparency, what's your take on this? Like, is this are they doing this because they're trying to cover up information? Is it embarrassing? Why would we be in this situation where an officer of Parliament is forcing ministers to go to court?
It has an impact on definitely the authority itself and on the credibility of the access because we're seeing longer delays, and now we're seeing departments either taking the orders in court or ignoring the orders so that they take extra time to respond to access requests that should have been responded within 30 days or within an extension that is legal.
So I have some historic ATIPs that were never completed. I got one that dates back to that we filed back on October 13th, 2017, just asking for a policy change document. We've got one back in 2018, just asking for, information surrounding national shipbuilding strategy, which, you think would be pretty easy to come by. Looking for, records and hospitality expenses of an employee, looking for information on, an Auditor General report and the correspondence that went back. And we're talking, I got 6 here that go back from 2017 to 2019. Should I file these with you to force the, as a member of Parliament, I don't know if I have that capability to come to you and say, make the department report. And we only, on some of these, are only starting hearing back from the department in the last couple of months. And they still haven't given us the information.
I was going to ask you, do you have complaints with my office? I don't think we do.
Should
I? Well, the process is there for that. And there's a timeline in the Act, and then if you don't get an answer within 30 days or within an extension that is taken legally, you have the right to make a complaint within 60 days of knowing why you want to make that complaint. So you have a right to complain to my office.
So is this being because it's the department or the minister, or are they incapable, are they incompetent, is it a lack of leadership, or is it a political scandal and a cover-up?
There's a lot of factors that affects a department's ability to respond. There's, like I said earlier, information management, the culture of the department, lack of resources, a lack of tools. All of these, often the leadership has an impact as well.
Mr. Mazan, 4 minutes is not 5 minutes. TMC stands for what?
Go ahead.
Trans Mountain Corporation?
Trans Mountain Corporation.
Okay, we were wondering again what TMC stood for. With that, it's Mr. Fisher, 5 minutes, 4 minutes.
Four. Thank you
Yes.
very much, Mr.
Not a Bazan 5 minutes, or not a Bazan.
Thank
4
you
minutes,
very
yeah.
much, Mr. Chair, and I want to thank the two commissioners and their teams for being here. It's funny, I had a prepared question, but I hear the frustration in your opening remarks, and I hear the frustration in your responses. Historically, we know, we heard 2007 referenced when it came to the budgets. We heard 2011 reference, Ms. Menard, you referenced 2011 and how bad things were. We know historically how bad things were under the previous government, but my goodness, it doesn't seem like it's getting a lot better. I can look at graphs and charts that show me that there's some minute improvements. This is really frustrating. You know, it's one thing for, you know, us to sit here and say the opposition years ago was really bad, and then sit over there and say, oh, you guys are really bad. We, as a committee and as a government and as ministers and as departments, need to do better. So, I'm sorry, but can you tell me, can both of you tell me, if you, in the remaining time I've got, what we need to do to, notwithstanding the IT system, well received, thank you for that, the budget, what do we need to do to get this ATI system fixed? I know that I'm not leaving you an awful lot of time, and I know I'm frustrated. I hear your frustration. I hear the frustration from members around the table. What do we need to do to get beyond what I see in charts as incremental improvements? I'll, you know, take 2 seconds to pat ourselves in the back for incremental improvements, and then get back to work. What do we need to do to make this better?
So I agree with you. Things don't change. When it's your information, you're protecting it, and when it's not your information, you want it. If you want things to be changed, you need to change the culture. The culture within the government, the leaders have to provide priorities, clear objective, resources, training, innovation. We need legislative changes, which right now we are going to be waiting until 2025 to have another round of legislative changes. And that's going to be just a start of the legislative change. There's going to be consultation probably. So I'm not even sure I'm going to be there for that. But we definitely need a stronger legislation. That act is 40 years old, and it hasn't changed that much. And we need investment in money and also in resources to respond to the access requests are not going to go anywhere. People are asking for information. They know they have the right to do it, and they are doing it.
Ms. Soloway, I think there's a little bit of time left.
I'm not quite sure how to answer. To be very transparent here, to my knowledge, I'm not sure that my predecessors have asked for a budget increase in previous years. So I cannot say that requests were denied. But I do think that we do need some flexibility built into our budget to be able to address sui generis situations, making sure that we don't waste money, but making sure that we have access to the money when we need it. I think that that's one particular issue. But as I said, it's going to be up to us, and this is what we're in the process of doing, looking at our organization, and we'll be ready, hopefully, by the next budget cycle to make a clear-eyed request about what is required.
Thank you very much for that, and thank you again both for your opening remarks, your comments to all of us, and I think it's incumbent on us as a committee to stop with the they're worse than we are, we're worse than they are, partisan sniping, and just get down to work and make this system better for you folks. Thank you.
Thank you, Mr. Fisher. A minute and a half, Ms. Normandine.
Merci beaucoup, Madame Ménard. Thank you very much, Madame Ménard. 2 weeks ago, I referred to your report in part, the 2020 report, where you said that officials don't tend to disclose too much to avoid sanctions, that sometimes they say that information is confidential, by force of habit, and often their task as to ATIP requests are one among many tasks. And some people say, oh, there doesn't seem to be a problem. The work is being well done. These are officials whose job is entirely to focus on ATIP requests. I'd like to hear what you have to say about this so that your testimony can also stand. It's true that the units that are dedicated to working on ATIP requests, that's what they do. And it's actually a vocation, to work on access requests. Because on the one hand, you have those people that are requesting the information that are unhappy about not having it. And then on the other hand, you have departments that don't want to provide you the information because they have other things to do. And the responsibility of officials under the Act, those are parts of their responsibilities. But I don't think it's something that they're taught, actually. And it requires some leadership to say that this is part of the priorities of their department, and it's not simply just a sideline that they don't really have to do because it's not important or it's no fun.
Normandine, minute and a half, Ms. Madison, maybe a couple more seconds.
Thank you. I don't want to put you in the middle, and I think Mr. Fisher has the best of intentions in terms of and he's certainly right in terms of it shouldn't be partisan. This should be about getting access out there. But when we talk about a change in culture, or you talk about leadership and showing that leadership, the need for the investment, the need for resources, I do often wonder how much of that is deliberate. In terms of when one group has power and the other wants information, and then the other one has power and they want information, how much do you think, or what can we truly do within that legislation to ensure that all of that partisanship is taken out of the equation, and to ensure that deliberate under-resourcing of institutions occurs?
Well, like we say, agency parliaments right now, there's only 2 or 3 that have an independent mechanism to obtain their own finances outside of the government. We are, unfortunately, some of the 2, or I think there's 6 of us that don't have a mechanism for independent financing. That's definitely would be the right step forward if I am able to obtain, as we say, the resources when there's a surge of requests or a surge of complaints, or when we have an IT system that falls, or like we don't have to use our own our own resources to fix things. That's a changing the law, making it stronger, making it a priority, making proactive disclosure a priority, and proactive disclosure being under my authority to investigate. Right now, Part 2 of the Act is not being even looked at. We don't even know if institutions are respecting their proactive disclosure obligations, because nobody has a purview or an authority to review that.
Okay, we're going to have to leave it there, unfortunately. Mr. Bazan, 4 minutes.
Okay. Commissioner Maynard, do you believe that what's happening in national defense, you got 3 court cases now that you've had to bring against the minister, is this systemic? Is this the new modus operandi, that they're going to continue to try to block you rather than be compliant with the legislation?
I really hope not.
Okay, we'll just have to watch to see what happens. Commissioner Salloway, you talked about that people within departments that are coming forward with information and complaints, that there is reprisals happening from their higher-ups. And when I look at the Department of National Defense, and we do have, when we do want to make sure that whistleblowers are protected, but there is things like the National Defense Act, the Security Information Act, and the non-disclosure agreements, which are being used now to hush people up as well. Is that undermining whistleblowers coming forward when they are seeing wrongdoing within the Department of National Defense, the Canadian Armed Forces?
I'm going to defer to Brian to answer that question, having been here only 4 months. I have not been around long enough to detect patterns. Over to Brian.
Fear of reprisal is definitely an issue, and perhaps, as it was alluded to before, when the internal disclosure regime does not work very well, it affects the entire disclosure regime. We do have jurisdiction over the Department of National Defense, but not the Canadian Armed Forces. However, we can investigate members of Canadian Armed Forces alleged to have taken reprisals. The consequences at the end of the process may be a little bit different for them in that they are not public servants under the Act. But indeed, it adds to the fear of coming forward with information, as does the fear that nothing will be done if I come forward with information.
So a CAF member can come to your office and still get a fair hearing?
No, a member of the CAF can provide us information as any member of the public can
But
with
that's
respect
only
to wrongdoing.
So you're strictly with D&D employees?
D&D employees with respect to wrongdoing, D&D employees with respect to making a reprisal complaint. People alleged to have taken a reprisal can, however, include a CAF member.
Okay. Mr. Chair, I just want to move a motion based upon testimony we've heard today, and I think it's fairly straightforward, that the committee extend the transparency within the Department of National Defence and Canadian Armed Forces study by adding one additional meeting and invite the Privacy Commissioner to appear. I think it was an error that none of us had the Office of the Privacy Commissioner on our list of witnesses. We heard today from Commissioner Maynard that some of the questions we asked should be best put towards the Privacy Commissioner. We know that members of the Canadian Armed Forces often have to ATIP their own medical files, and that falls underneath privacy, as well as some of the other information that is being requested from Canadian Armed Forces, so as well as Department of National Defence. And so I think it would be inherent upon us to request that the Privacy Commissioner appear as well.
The motion is in order, obviously, and I don't think we'll have a debate, but just for the information, the committee, we've already invited the Privacy Commissioner. It's just a case of negotiating a time. So, yeah. We've extended an invitation. So,
Mr. Chair, I just want to understand, so the member, Mr. Bazan, has brought in a motion, and you're saying that this particular individual was already on the list of witnesses?
I don't think he was on the list of witnesses. We'd already.
But you had already suggested that he should be coming, or this organization
We have a
is.
superior chair and a superior clerk here. and
We always
already
believe that,
anticipate
Mr. Chair,
every need
yes.
of the committee. Yes.
You're well supported by a wonderful clerk, Mr. Chair, yes.
What?
So the invitation was sent, is that what I'm hearing?
We have extended the invitation.
Okay, perfect, thank you.
Final 4 minutes goes to.
No, we're on debate.
Oh, you still want to debate? I'm sorry. Ms. Madison.
I would argue that we probably should still have the motion go forward because the invitation may be sent, but a further request from the committee would be valuable. But I would actually like to amend that motion.
Sorry, you want to amend the motion? Okay.
So what it would read, with my amendments included, is that the committee extend the transparency study? Sorry, it's missing a word. Within the Department of National Defence and the Canadian Armed Forces, study by 2 additional meetings and invite the Privacy Commissioner, Chief of Defence Staff General Wayne Eyre, and former DND CAF Ombudsman Gary Walburn to appear.
Okay. Debate. Further debate on Madame Lalonde?
I just would like to have an understanding. I know we've been very generous with this important motion in terms of facilitating. I know there's other motions that we would like to take. We have also agreed on extension on the housing, and I'm not disputing this is a very important subject matter. What is the rationale maybe of Mrs. Madison as to why inviting, and it's 2 more? So that's a 4-hour. Is that what I'm hearing, or it's a 2-hour? So I just wanted to understand, in hindsight of everything and with everything that's piling up on our desk in this wonderful committee, I'm not saying it's a no from, I just wanted to understand. Thank you.
Go ahead.
So originally, when I had put forward this motion, I had expected it to be longer, and as the committee will remember, it was shortened. As we've discovered, there's a lot here to dig into. I think that we owe it to the folks who have come, the witnesses who have come and shared their time to do a fulsome study as we need to. I had originally also asked for the Chief of Defense Staff to appear because he is the final say, and we have heard him and his office referenced several times today in previous meetings as to that final authority on information and access to said information. So I think that that's really important. And even today, with the Ombudsman, as incredible as Mr. Lick is and his office is, a lot of that context and historical context of what happened with former Ombudsman Walburn, I think is important to this study. If we feel we're able to do it in a meeting and a half, fair enough, but with the depth of these witnesses, I considered that 2 meetings was appropriate.
You were up first? Yeah. Mr. Bazan, and then...
So I support the amendment, and I believe that what we heard this morning from the Military Grievance Committee, that they do take direction from the CDS, that they do refer files, so we do want to hear from the CDS. And I think that also based upon Mr. Lick's testimony this morning, as well as his comments surrounding about the independence of the office. When Mr. Walborn was the Ombudsman, he had proposed legislation, and I think we should talk to him about the importance of having the office as an independent parliamentary office and able to do the investigations that are required. This is in the interests of those that serve, our Canadian Armed Forces and those in the Department of National Defense, and we want to make sure that we are promoting a culture of transparency. And I think that by digging in deeper in the study helps send the message about that culture change that needs to happen to ensure that we have collaboration and cooperation by the department officials and the minister himself.
Ms. Lalonde.
I really, as always, I like on the last minute of every committee, without any proper notification or information, we get to know we didn't see anything in writing. We have a wonderful amendment that sub-amendment that I think it will be interesting to see in paper, in a write-up situation. So maybe, Mr. Chair, we could have it, just adjourn. We can see, and then we can come back to the discussion.
Is that a motion to adjourn?
It is.
Okay. Adjourn the meeting or adjourn the debate? All right. What are we adjourning? Are we, Marie-France, are we adjourning the meeting or the debate?
Well, I would like to adjourn the debate.
Okay, then that's a dilatory motion. Those in favor? Mr. Clerk.
Do a call? Okay. Sorry. Mr. Fisher? Yes. Mr. Fillmore?
Yes.
Ms. Lambropoulos?
Yes.
Mr. Collins?
Yes.
Ms. Lalonde?
Yes.
Mr. Bazan?
No.
Ms. Kramp-Nyman?
No.
Mr. Kelly?
No.
Ms. Gallant?
No.
Madame Normandin?
No.
And Madame Matheson?
No.
Okay. The motion to adjourn debate fails. So we're back on the motion itself, or sorry, both the motion and the sub amendment. Any other debate? Mr. Fisher.
Can we get the amendment? This is just James's motion. Is there a way of getting the amendment as the amended motion?
I don't think you have, she has it in writing. Do you have it in writing?
Point of order.
Yeah. Go ahead.
The motion, if I understand from your ruling, Chair, the motion is in order.
Oh, we're not talking about that.
Okay,
We're talking about, we're trying to find,
therefore, we ought to just continue,
No,
and if there is no debate, it would go to a vote.
the amendment also is in order. I'm asking for whether there is a written copy of the amendments so that we all know what we're talking about. And the clerk has got it?
In one language, I have it.
Oh.
I can't distribute it because I don't have it in both languages.
Okay. You can read it into the record.
I can read it into the record. Well, it has already been read into the record.
Right. Okay. Order. We don't have it in official both languages. It has been read into the record, but for point of clarification, I'll ask the clerk to once again read it into the record so we know what we're debating.
If I may, would you like to allow the witnesses to leave at this point?
It looks like we're pretty well
Excuse
past
the
the time
witnesses,
anyways, unless you really want to stay for this really thrilling exercise in democracy here. Yeah, okay. Thank you again. Thank you. Thank you. Okay, Mr. Clerk, let's just, so that we all know what we're talking about here, the same thing.
Perfect. So the motion, the amendment, I'm going to read the whole motion with the amendments that have been suggested by Madame Matheson. So the motion would read that the committee extend the transparency within the Department of National Defense and Canadian Armed Forces study by 2 additional meetings and invite the Privacy Commissioner, the Chief of Defense Staff, and former DND-CAF Ombudsman Gary Walburn to appear.
Okay, everybody understood? Any other, Madame Mr. Okay, Mr. Fillmore.
Debate on the motion. Is that where we're at right now?
On the amendment.
On the amendment, rather?
Yeah.
I would like to offer this team's support of the amendment to the motion on the condition that the new Ms. Matheson should hear this if she could. I think we're prepared to support your amendment to the motion on the condition that the witnesses come, take their place at the back of the line and come after the space study. And with that condition, we're supportive of what you're proposing. But we need to get to space. We've seen what's in the news with Russia's satellite killing technology. We need to get moving on this, and the window for travel is closing.
So while I would have no issue if we and I have so much faith in the competency of this committee that we could probably handle both at the same time if we wanted to start, because sometimes witnesses, and I know that the clerk, as incredible as he is, may have difficulty fitting witnesses in. So potentially one day we start, and I know that there's actually another study before the space study as well. So if we can juggle a little bit, then and fit in people as we need to, so that we're not wasting that time, then that would be amazing. And I'm fully prepared to do that.
Okay, well, that is more of an undertaking than it is anything to do with a motion or an amendment to the motion. But having said that, Mr. Brazan.
And just on substance, again, first of all, we support the motion. Secondly, Mr. Fillmore's comments, I think that is something that the subcommittee or you as chair manage the timeline of the committee as best you possible. And I think that there's opportunities to be juggling. We know that CDS and the Privacy Commissioner are both here in Ottawa. They're if they need to find witnesses, they're easy enough to pull in to fill any spaces that might happen in our calendar. But at the same time, I don't want to hold back on the space study, especially on the travel side, so that we can get going on it and starting off that study.
Reminds me, I got to ask.
We can walk and chew gum at the same time.
Yeah. Any other points of debate? First vote is on the amendment. Those in favor? Those opposed? And then the amendment, or the motion as amended. Those in favor? Those opposed? Okay, thank you very much. Final point before we adjourn, I need someone to move the budget for this transparency study, which we said is 6,000 on 2 meetings. Now, anyways, we'll see whether we can get by on 6,000. Chad, was it? Any debate? None? Sir? Motion passed. Thank you. Meeting adjourned.